Hello, everybody, and welcome back to my lecture series. I'm Dr. Mark Leiser. In this video, I want to take up a question that looks very simple and actually does a great deal of legal and normative work. And you may have heard a lot of this in the context of the Unfair Commercial Practices Directive, maybe some people talking about digital technologies and how profiling and behavioral manipulation are so they're everywhere online. And so you may have heard the expression that information asymmetries and digital profiling take place at such scale that we need to rethink the way we think about vulnerability or the legal concept of vulnerability. And so what this question, what this lecture is going to ask is, what does it mean to say that a person is vulnerable in a digital environment? I'm going to try over the next 30 to 45 minutes to try and give you an answer, but not a deliberately easy one. I'm going to argue that not every user is vulnerable simply because they are online. And this goes against a lot of the narrative that is coming out now from some of the consumer protection people who I have a lot of time for and I've done a lot of work with. Especially in my relationship, my work with dark patterns and deceptive design. And I just think it goes too far. What I want to argue is not that every user is vulnerable simply because they're online. I don't think it's conceptually precise, legally useful, or normatively attractive. And it risks turning the digital consumer into a permanently deficient subject, someone that is always presumed to be weak or passive or in need of rescue or special considerations. But I also don't think that vulnerability should be confined to a very small list of fixed categories. So it's not enough to say that only children, older people, disabled persons, or people in poverty or come from challenging economic backgrounds are vulnerable. Those categories matter. They're legally and, more importantly, morally important. But the digital environment can create vulnerability in people who do not normally see themselves as vulnerable at all. A sophisticated adult, for example, can be vulnerable at 2 o'clock in the morning when they're tired, emotionally depleted, and confronted with a personalized sequence of urgency prompts. A financially secure person can be vulnerable to a system that has learned the triggers of what amounts to compulsive engagement. And a teenager is not vulnerable in every interaction, but can be made acutely vulnerable when a platform detects anxiety, low self-esteem, or the need for social validation, and then feeds those signals back into an engagement loop. So the central distinction in this video is that vulnerability should not be understood solely as a user's status. It should be understood as a relation between a person, a system, and a context. And this is a central argument, maybe not a central argument, maybe a secondary argument in my book, Dark Patterns, Deceptive Design, and the Law. My book is not just a list or chapter by chapter of bad interface tricks. So I talk about the harms and the typologies about dark patterns, and ultimately I want to see it as an argument about digital power, optimization, and the law's difficulty in detecting manipulation once it moves beyond the interface's surface. In chapter 6 of that book, I asked a question that has stayed with me. If a developer tasks an AI system with increasing engagement, increasing conversion, or increasing profitability, what means will that system discover? What will they do to get to that outcome? It'll not be necessarily told to deceive, and it may not be programmed with a rule that says exploit cognitive fatigue or target emotional distress or deploy whatever dark patterns you need to get there. But if the optimization objective rewards those outcomes, then the system can learn strategies that sit somewhere between persuasion, manipulation, and exploitation. That's why the older language of dark patterns is no longer enough, and that's one of the reasons why I push towards deceptive design. The button, the timer, the hidden fee, the cancellation maze, these still matter. But the deeper problem is the architecture that decides who sees which interface at which moment, with which salience, with which friction, and in response to which inferred susceptibility. In this video, I want to make a high-level legal argument. The question is not whether you and I are weak. The question is whether the system makes weakness profitable. And that's the framing I want to carry throughout the whole lecture. Do not pathologize the user. Discipline the environment. And I hope you are able to take that away or keep that in the back of your mind as we go forward. Now, the core thesis is that vulnerability in digital law should be relational rather than constant. And a vulnerability event occurs when three things, I think, come together: the person, the system, and the context. And so the person brings human limits. That includes your attention, your fatigue, emotion that you may have in the moment, impulse controls or lack thereof, trust. Digital literacy is important as well. Money, time, confidence, anxiety, and even sometimes desperation. These are not pathologies. They're ordinary features of human life. You may be completely engaged, 100% in the flow at 8 a.m. in the morning, or maybe you need to wait until 10 o'clock until after your coffee. A realistic account of law must begin with the fact that humans are not perfectly rational, perfectly informed, or permanently alert decision makers. Now, when I say that out loud, it should be self-evident or obvious, but too many times our law creates this kind of artificial actor that we measure success of a law against. And I've written about why this is really problematic from my early days as a PhD student. So the system brings a different kind of capacity. It brings data, inferences, rankings, recommendation, friction, defaults, timing, interface adaptation, and commercial objectives. The system is not tired. It never runs out of energy. It never runs out of computational power. Its limits are basically how it's been programmed. It can test or not test. It can learn. It can be personalized. It can observe millions of interactions and refine the choice architecture in ways that you and I would never be able to match. So the context then supplies the stakes. The same design element can have a very different normative meaning depending on whether the user is buying a book, applying for credit, seeking mental health support, making a health decision, canceling a subscription, or navigating a stressful administrative process, applying something from the government. That's why I don't think the correct legal question is the user vulnerable? Because you can always say that a user is vulnerable. But that question pushes us too quickly towards status categories. And it asks whether the person belongs to a group that the law has already recognized as vulnerable. A better question, I think, is whether the system has produced, identified, intensified, or exploited a vulnerability in this particular decision environment. This gives us a more disciplined account. It also avoids universalizing vulnerability while still recognizing that any user can be rendered vulnerable under the right conditions. It also shifts attention from the alleged weakness of the individual to the system's conduct. So there's a familiar tension here in consumer law. On the one hand, consumer law has historically worked with abstractions like the average consumer or homo economicus. Reasonably well-informed, reasonably observant, reasonably circumspect. That figure performs an important function. It stops consumer protection from collapsing into a purely subjective inquiry. And it gives traders and regulators and courts a baseline of what's acceptable behavior and what's not acceptable behavior. On the other hand, the digital environment makes that baseline increasingly unstable. Personalized systems do not necessarily address the average consumer. They address the consumer now, with this inferred profile in this moment under these conditions. So the average consumer is still legally useful, but no longer descriptively sufficient. The law needs a way to understand how digital systems fragment the consumer experience and create distinct decision environments for different people. That's why I use the concept of a vulnerability event. It lets us say that vulnerability is not a permanent label. It's a condition that can arise when the user's limits meets the system's power in a context of pressure. So a capable user in one setting might be completely rendered vulnerable in another. A person who can understand ordinary advertising may not be able to understand why an app is presenting them with a particular option at a particular time. A person who can compare products in a neutral marketplace may not be able to resist an adaptive environment that is learned when comparison is least likely. That's not a theory of helplessness. That's asymmetry, right? And the legal consequence of this asymmetry is important. If vulnerability is relational, then the focus of regulation should not be on sorting users into the strong and the weak. It should be on the design, the deployment, and the optimization of environments that exploit predictable human limits. Now, this brings me to the distinction between dark patterns and deceptive design. The term dark patterns has been tremendously useful. I run or help run the Deceptive Design enforcement database at the Deceptive Design website. And this database, in theory, was to help regulators and the public recognize the practices that had previously seemed like isolated annoyances. So the hidden cost, the pre-ticked box, the false scarcity message, confusing cancellation routes, the confirm shaming prompt, the button that is designed to make the protective choice look really unattractive. But the term can also make the problem too visual. And it encourages us to simply look at the screen and ask whether there was a manipulative element that we could point to. Is the button misleading? Is the disclosure hidden? Is the timer false? Is the cancellation flow obstructive? They're still good questions. Like, don't get me wrong, I don't want people to stop doing a kind of visual audit of the type of screens that people are seeing. But they're no longer enough. The problem I'm interested in is deceptive design, which is not limited to visible user interface tricks. This includes the whole system architecture beneath the screen, the data collection, the behavioral profiling, the ranking logic, the recommendation systems, the adaptive friction, timing, pricing, disclosure strategies, and optimization objectives. This matters because a platform can always present a very clean, elegant, apparently neutral interface, while the underlying architecture is doing all the real work of exerting influence. So if I was to go in and take a screenshot, it would look clean. It would look lawful. And at the same time, the underlying architecture can still remain exploitative. So this is the key lesson of my book in AI-powered deceptive design. Once systems become adaptive, the manipulation may not appear as one stable interface element. It may appear as a pattern of differential treatment. One user sees urgency, another sees reassurance, another sees friction, another sees social proof, Another sees reduced visibility of the cheaper options. And another sees an offer when the system predicts fatigue or distress. So, like, more normatively speaking, how can you have an average consumer if every consumer is seeing something different? And that means that the law can not only ask what the interface looked like in the abstract, it has to ask what the system did. What did it infer? What did it change? What did it make salient? What did it hide in the architecture? What did it make easier? What did it make harder? What outcome was it optimizing for? And how did those choices interact with the user's capacity for informed, autonomous decision making? In Chapter 6, I use AI-powered recommendation engagement systems to show why this is difficult. These systems can combine deterministic and non-deterministic elements. Some parts of the system may be rule-based. Other parts may learn from behavior and adjust in real time. The result is an environment that feels natural to the user, yet continually learns to increase engagement, conversion, or revenue. That is why it's misleading to treat dark patterns as a fixed list of bad tricks. The list is useful, but the strategy is broader. A system does not need to use the same dark patterns for everyone. It can learn which techniques works for which person and under which conditions. This is why enforcement becomes difficult. A regulator can inspect a web page. A regulator can inspect a standard contract term. A regulator can capture a screenshot or a misleading interface. A regulator can train AI to go look for these interface tricks so they can start enforcement proceedings. But how does a regulator inspect an adaptive environment that behaves differently for different users and may not reproduce the same journey twice? The legal problem is no longer simply evidencing a misleading representation, it is evidencing an architecture of influence. That is a deeper problem. It requires auditability. It requires logs. It requires access to system objectives, testing practices, deployment data. It requires a shift from focusing solely on the visible interface to understanding the system's design logic. So when I say that the interface is only the tip of the iceberg, I mean that the most important legal and normative questions often sit beneath the surface. The visible interface asks, what did the user see? The architecture asks, why did the user see this at this moment and in this form, and in whose interest? So the next step is to distinguish different kinds of vulnerability. At a very or merely philosophical level, vulnerability is universal. All human beings are vulnerable at any given time because we're embodied, dependent, finite, and imperfect. We age, we become ill, we get tired, we rely on others, we make mistakes, we misread information, we act under pressure. We are not machines. But universal vulnerability is not a good legal test. It's too broad. If every person is vulnerable at every moment, then vulnerability ceases to distinguish anything. It cannot tell us when persuasion becomes manipulation, when personalization becomes exploitation, or when a design practice crosses the threshold of legal intervention. So the law needs a more structured vocabulary. There is situational vulnerability, fatigue, distress, urgency, grief, distraction, loneliness, time pressure, intoxication, and cognitive overload. These conditions are temporary, but they can significantly reduce the quality of someone's decision making. At the same time, there's systemic vulnerability, poverty, discrimination, exclusion, precarious employment, low digital access, low trust of our institutions, or structural dependence on a platform or service. These vulnerabilities are not merely individual. They are produced by social and economic arrangements. There's also informational vulnerabilities, opacity, asymmetry, profiling, inference, hidden data use, and the inability to know what the system knows or why it is acting as it does. This is central to digital environments because the system often possesses a behavioral map of the user that the user cannot inspect. You can't legislate for this through a transparency requirement. This is sloganization of legal principles. It doesn't work. There's also psychological vulnerability, anxiety, low self-esteem, impulsivity, insecurity. The number of people that think something is about them when nobody is referring or talking to them about. Compulsive engagement, fear of missing out, social comparison, dependence on validation, or even the susceptibility to emotional pressure. And these categories interact. Now, chapter 7 of my book uses this vulnerability cycle to make this point. Informational asymmetry enables psychological manipulation. Psychological manipulation can deepen the systemic disadvantage that one has. And the systemic disadvantage can intensify informational vulnerability. So these layers actually reinforce one another. That's why vulnerability should not be treated as a simple attribute. It is not something the user either has or lacks. It's layered, it's relational, and it's dynamic. The EU's AI Act recognizes some of this, but only partially. Article 5.1b prohibits AI systems that exploit vulnerabilities due to age, disability, or a specific social or economic situation where that exploitation materially distorts behavior and causes, or is reasonably likely to cause significant harm. It's an important provision. It marks a legal recognition that some AI-enabled forms of exploitation are unacceptable. But its protected vulnerability categories do not cover all meaningful vulnerability events. So behavioral addiction, grief, fatigue, loneliness, compulsive engagement, emotional distress may not fit neatly into these concepts of age, disability, or socioeconomic status. These are precisely the conditions that adaptive systems may be able to detect or exploit. This produces a gap between legal vulnerability and design vulnerability. Legal vulnerability asks whether the person falls within a category the law recognizes. Design vulnerability asks whether the system has found a susceptibility it can use. That gap matters. If the legal test is too narrow, the system can exploit vulnerabilities that are real, but not legally recognized. If the legal test is too broad, the law risks regulating ordinary persuasion as though it was exploitation. The task then is calibration. We need to recognize that humans are not perfectly rational without treating ordinary human imperfections as a legal disability. We need to protect against exploitation without assuming that every influence is manipulative. We need to preserve autonomy without imagining that autonomy requires a frictionless, influence-free environment. This is why the argument must be vulnerability sensitive rather than vulnerability universal. So, influence is not the enemy. This is where the normative line becomes really crucial. For me, commercial life is full of influence, and some of that influence actually helps us. A shop places products at eye level. A website recommends related products. A platform makes a service easier to navigate. A seller takes an opportunity to highlight certain benefits. The designer reduces friction. And a public authority may design a form so the welfare-enhancing choice is actually easier to make. None of that is inherently wrongful. The legal and the normative question is not whether the user has been influenced. Of course they have, right? The question is whether the mode of influence respects or undermines their agency. So I think it's useful to distinguish 4 categories in this point. The first is persuasion. Persuasion is open, contestable, and compatible with reflection. The user knows that they're being addressed. When a grocery store puts all the staples of our food and diet in the back of the shop, you still have the ability to not buy them. You can walk in and buy something at the front. Even if you walk to the very back of the shop, it doesn't mean you're going to stop off and buy something because you had to walk past items to get to the milk and the bread or the eggs. Like that's a definition of reasonable commercial persuasion. The purpose is reasonably apparent. You can evaluate the claim and still reject it. Persuasion can also be emotional. It can be vivid. It can be commercially motivated. It doesn't hide the basic nature of the influence. The second is nudging. Nudging structures the choice environment. It makes defaults, salience, timing, simplification, or friction. Nudging can be legitimate. It can be completely legitimate. It helps users make choices they have already have reason to endorse. It can help reduce complexity. It can support welfare. But nudging becomes more troubling when it's asymmetrical, when the platform makes the commercially preferred outcome easy and the user-protective outcome difficult. The third is manipulation. Manipulation interferes with the user's deliberative process. It uses hidden intent, information asymmetry, cognitive bias, emotional pressure, or the opacity to steer behavior in ways the user cannot reasonably understand or resist. The user still formally chooses, but the conditions of choice have been engineered against meaningful autonomy. So here, I think that this could be delivering up ads to a gambling addict, or selling promotions or sending promotions to somebody that has trying to recover addiction. Now, in this sense, like the user can still formally choose to place a bet, but the conditions of choice have been engineered against any meaningful autonomy. And the final one is exploitation. Exploitation is the category that matters most for the balance of this lecture. It occurs when a system uses a vulnerability, whether that's known, inferred, or created against the user. And this is the sharpest normative line, in the sense of exploitation is not merely successful persuasion, it's the use of asymmetry to convert human limitation into commercial advantage. This also helps us understand material distortion. In EU consumer law, particularly in the logic of the Unfair Commercial Practices Directive, the law is not offended by every influence on consumer behavior. It targets practices that materially distort, or are likely to materially distort, the consumer's economic behavior. That requires more than a trivial nudge. It requires a meaningful impairment of the conditions under which the consumer chooses. But digital systems complicate this because material distortion may be cumulative rather than dramatic. A single notification may not distort behavior. A single recommendation may not distort behavior. A single design choice may not be manipulative. But a system that repeatedly tests the timing, the salience, the emotional pressure, and disclosure against the user's behavioral profile can gradually reshape the user's decision environment. That is why autonomy is not just about consent. A user can click, a user can agree. A user may have technically been given information, but if the system has structured the environment so that the user is unlikely to notice, understand, compare, or resist, formal consent does not settle the normative question. Transparency is not on its own sufficient. A platform might disclose that it personalizes content. That doesn't tell the user whether the system is using fatigue, anxiety, impulsivity, or financial desperation as optimization variables. The wrong is not merely that the user lacks information. The wrong is that the system has weaponized that asymmetry. That is why the distinction between persuasion and exploitation really matters. Persuasion treats the user as a reasoning agent, and exploitation treats the user as a behavioral object. A legal system committed to autonomy, fairness, dignity, and equality should not ban influence. It should discipline influence when it is hidden, asymmetric, and extractive. So the question I would ask any of the digital design practices is not, did it influence the user? That's just silly. The question is, did it respect the user's agency? Or did it extract value from the predictable limits of that agency? The AI Act of the European Union is important because it recognizes that some forms of AI-enabled influence are not merely risky or the need of disclosure. They are unacceptable. Article 5.1a prohibits AI systems that deploy subliminal techniques beyond a person's consciousness or purposely manipulative or deceptive techniques, where those techniques materially distort behavior by appreciably impairing the person's ability to make an informed decision, causing a decision that would not have been taken otherwise, not have been taken in a manner that causes or is reasonably likely to cause significant harm. There is a lot to unpack in 5.1a. 5.1b addresses a related but distinct problem. It prohibits AI systems that exploit vulnerabilities due to age, disability, or a specific social or economic situation, again, where the objective or the effect is material distortion of behavior and significant harm. At the level of principle, these provisions are significant. They recognize manipulation, deception, and exploitation as fundamental rights problems. They also move beyond transparency. They don't simply say, tell the user. They say some practices should not be placed on the market, put into service, or used at all. But a prohibition is not self-executing. It's one of the themes in my wider work in EU digital law, and some of my previous lectures on this topic are available on my channel. A prohibition can express a strong normative instinct while still leaving difficult operational questions. The Article 5 test is also cumulative. We need an AI system. We need a relative technique or exploitation of a recognized vulnerability. We need material distortion of behavior. We need appreciable impairment of informed decision-making. We need a decision that the person would not have otherwise have taken. And we need significant harm or a reasonably likelihood of significant harm. Each of those elements can be difficult, but together, and this is a main argument of my book, is that threshold's really high. And that high threshold is not accidental. Prohibitions are serious legal tools. They should not capture ordinary persuasion, ordinary personalization, or ordinary usability design. But the risk is that the threshold may miss precisely the kind of cumulative, adaptive, personalized manipulation that digital systems are increasingly able to perform. Chapter 6 develops this point through case studies. A shopping platform targets users during periods of cognitive fatigue. A financial app downplays fees for users predicted not to read terms. A fitness or health app sends emotionally charged prompts at moments of low motivation or anxiety. In each case, there's a plausible argument that the system is doing something troubling. But there's also a plausible defense. The system is personalizing recommendations, improving usability, supporting engagement, or preventing information that remains technically available. This is where the legal difficulty lies. The wrong may be real, but the prohibition may be difficult to apply. Article 5.1b has a similar problem. It recognizes vulnerability. It does so through specified categories: age, disability, and specific social economic situation. Those are important, but they may not capture grief, loneliness, compulsive engagement, behavioral addiction, or temporary emotional distress unless they can be linked back to one of the recognized categories or to another legal route. So Article 5 is powerful and limited at the same time. It's powerful because it gives us a vocabulary of unacceptable AI practices. It says that manipulation and exploitation are not merely matters of consumer irritation. They implicate autonomy, dignity, fairness, and fundamental rights. It is limited because it may apply most clearly to the dramatic case, the demonstrable technique, the recognized vulnerability, the measurable behavioral distortion, the significant harm. Many of the hardest cases sit below that level. They are not harmless, but they may be incremental, probabilistic, cumulative, and difficult to evidence. The Commission's guidelines on prohibited AI practices try to give some sort of operational meaning to Article 5. They provide examples and interpretive guidance, but they're non-binding. An authoritative interpretation remains for the Court of Justice. That means that the difficult boundary between lawful persuasion and prohibited manipulation will develop through regulatory practice, litigation, and institutional learning. For lawyers, that means Article 5 is not the end of the analysis. It's the beginning of a more demanding question. What kind of evidence, architecture, and accountability do we need to make these prohibitions usable? For designers and deployers, the point is even simpler. You cannot defend an optimization strategy merely by saying the user clicked. The question is whether the system impaired the conditions under which the click became meaningful. And for regulators, the challenge is to see the system, not only the screen. So let me make this concrete through 3 vulnerability events. The first is late night shopping. An online marketplace uses an AI-powered recommendation engine. It tracks browsing habits, purchase history, comparison behavior, time of day, signs of reduced deliberation. It learns that a particular user is more likely to make impulsive purchases late at night, so it increases emotionally appealing recommendations, urgency cues, and high-cost prompts during that window. The user is not vulnerable because they are shopping. The user is not vulnerable because they are online. The user is not even necessarily vulnerable because it's late. The legal question is whether the system detected reduced deliberative capacity and used that moment to steer the user towards a transaction that benefited the platform at the user's expense. That is a vulnerability event. Fatigue plus system inference plus commercial optimization. The second is the financial app. Imagine an app that learns which users skip fine print, abandon comparison screens, or show decision fatigue. For those users, it places fees behind additional layers, makes lower cost options less salient, and presents the expensive option as the simple path forward. The platform can say that all information was technically available. The user could have clicked. The user could have read. The user could have compared. But that response misses the point. The issue is not whether the information existed somewhere. The issue is whether the system personalized opacity. That phrase is important. Personalized opacity. A traditional disclosure problem is that the trader failed to inform. A personalized opacity problem is more troubling. The system has learned how not to inform this user. The third example is the teenage mental health loop. An app or a platform identifies users showing signs of anxiety, low self-esteem, or social insecurity. It then uses infinite scroll, recommendation systems, social comparison signals, and targeted advertising to keep those users engaged. It interweaves beauty products, weight loss products, paid confidence courses, or lifestyle content that intensifies the very insecurity that the system has detected. This case is especially troubling because the vulnerability is layered. Age matters, emotional development matters, psychological state matters, commercial incentive matters. The recommendation architecture matters. But even here, the legal question should be precise. The claim is not that every teenager is helpless, or that all mental health content is manipulative or that every recommendation is exploitation. The claim is that a system should not detect insecurity and then make that insecurity profitable. These examples show why feature-based regulation is not enough. Urgency is not always wrongful. Some scarcity is real. Some reminders are useful. Some recommendations help users. Some friction prevents harm. Some personalization improves accessibility. The normative stakes depend on the system's function, context, target, and effect. A countdown timer attached to a genuine temporary offer is different from an adaptive scarcity strategy deployed against users predicted to respond to urgency. A simplified financial interface is different from one that hides costs from users predicted not to inspect them. A supportive mental health reminder is different from an engagement loop. Different from an engagement loop that monetizes insecurity. The issue then is not the label attached to the design feature, it's the strategy. What vulnerability did the system detect? What did it intensify? What did it exploit? What outcome was optimized? Who benefited? Who bore the risk? Those are the questions that make vulnerability legally useful without turning every user into a vulnerable subject. This leads to the regulatory framework I would propose. The aim should not be vulnerability universal regulation, like some people are proposing. That would treat all users as vulnerable at all the time. It would make the concept too broad and would risk over-regulating ordinary persuasion, beneficial persuasion, and legitimate design. Nor should the aim be vulnerability exceptional regulation. That would protect only a narrow set of recognized groups and leave many vulnerability events outside of the law's field of vision. The better model is vulnerability sensitive regulation. A vulnerability sensitive approach asks 5 questions. First, what does the system infer? Does it infer fatigue, impulsivity, financial desperation, emotional distress, low self-esteem, digital illiteracy, susceptibility to urgency, or a tendency not to read terms? Second, how does the system adapt? Does it change ranking, timing, friction, price, salience, disclosure, default settings, cancellation routes, or emotional framing? Third, can the user contest it? Can the user understand what happened? Can they opt out? Can they reverse the decision? Can they access the relevant information, or is the relevant influence hidden in the architecture? Fourth, who benefits and bears the risk? Does the personalization support the user's interests, or does it shift risk onto the user while concentrating informational advantage in the platform? Fifth, can the system be audited? Can a regulator reconstruct what the system inferred, what it changed, what the user saw, and why? The last question is crucial. Without auditability, personalized manipulation becomes legally invisible. If every user sees a different environment, the regulator needs more than screenshots. The regulator needs access to the design logic and evidence of the system behavior. This is where burden shifting and presumptions become important. If a firm builds an adaptive system that personalizes the choice architecture based on behavioral patterns, and if that system operates in a high-stakes domain or targets users at moments of reduced capacity, it should not be enough for the firm to say, the user chose. The firm should be able to explain what the system optimized for, what signals it used, what constraints were imposed, what harms were considered, and how exploitative outcomes were prevented. That is not anti-innovation, it's disciplined innovation. Personalization can be valuable. It can improve accessibility. It can reduce search costs. It can help users find relevant services. It can make digital environments easier to navigate. The legal target should not be personalization as such, The legal target should be deceptive optimization. By deceptive optimization, I mean optimization that uses the system power, behavioral prediction, opacity, and asymmetry to secure outcomes that undermines the user's autonomous interests. So the regulatory task is not to ban all nudges, all recommendations, all personalization, or all engagement design. It is to identify when those tools become part of an exploitative strategy. That's the difference between regulating isolated tricks, dark patterns, and regulating architectures of influence. Which takes me to the Digital Fairness Act. Fairness needs realism. The Digital Fairness Act is the natural place to advance this argument. Now, as I've explained already, there is also an argument that we don't need a Digital Fairness Act because we have 51A and 51B. But the emerging debate is not about whether existing consumer law needs updating. It's whether EU law can develop a more realistic account of digital fairness. But fairness needs realism. It cannot assume the perfectly rational consumer anymore. Humans have limited attention. We respond to emotion. We are affected by urgency, by fatigue, by social comparisons to our friends. Environmental design. A law that assumes otherwise will only protect a fiction. But fairness cannot also assume permanent vulnerability. If the law treats every user as always vulnerable, it loses the ability to distinguish ordinary influence from exploitation. It also risks generating rules that are too broad, too blunt, and too attached from how useful digital services actually work. So the Digital Fairness Act should not target human imperfection. Human imperfection is not a legal wrong. The wrong is the exploitation of those human limits by systems designed to optimize against the user. That's the balance I would want the law to strike. The DFA should be concerned with dark patterns, addictive design, unfair personalization, influencer marketing, subscription traps, and other potentially problematic digital practices. But it should not simply turn those concerns into a list of banned features divorced from the context of how they got there. Autoplay is not always harmful. Infinite scroll should not always be unlawful. Personalized recommendations are not always manipulative. Friction is not always bad. A reminder is not always coercive. A simplified interface is not always deceptive. The legal question should be limited to what is the optimization strategy? Does the system optimize by helping the user achieve a goal that they can reasonably endorse? Or does it optimize by exploiting a vulnerability event? That test allows the law to distinguish helpful personalization from exploitive personalization. It allows the law to distinguish ordinary persuasion from manipulative targeting. It allows the law to avoid both underprotection and overreach. This is where the DFA could complement the AI Act. Article 5 of the AI Act deals with the most serious prohibited practices, but many digital fairness issues will be broader than those of Article 5. They may involve non-AI design, lower threshold harms, the cumulative effects, or business models that fall short of the AI Act's prohibition standard but still undermine consumer autonomy. The DFA can therefore do something different. It can regulate the commercial strategies that make deceptive design profitable. It can address exploitative optimization even when the system does not meet the high threshold set by Article 5. It can clarify burdens of proof. It can create presumptions from high-risk design strategies. It can require stronger auditability of personalized choice architecture. It can impose duties around cancellation, disclosure, ranking, and vulnerable users without assuming that every user is permanently vulnerable. The key is proportionality. A fair digital law should ask, how likely is the harm? How serious is it? How foreseeable is it? How avoidable is it? And what would a proportionate design obligation look like? That's a more mature way of simply saying, ban manipulation, man. Everybody agrees on the easy case. The hard work is building a principle that spans platforms, interfaces, business models, and user contexts without yielding absurd results. So my proposed DFA principle would be this: regulate optimization strategies that exploit vulnerability events, not human weakness, not all persuasion, not all personalization, not all friction, and not all engagement. Regulate the strategy by which a system detects, creates, intensifies, or exploits reduced autonomous capacity in order to secure a commercial outcome. That is fairness with realism. It protects users without infantilizing them. It respects innovation without licensing exploitation. And it recognizes that humans are not perfectly rational, but it doesn't convert ordinary humanity into permanent legal vulnerability. And it makes the central target clear, not the user, but the business model that turns vulnerability into revenue. Let me close by putting the argument into its shortest form. We should not build digital law around the fiction of the personally rational consumer. We should also not build it around the fiction of the permanently vulnerable user. The better account is relational. A user is not vulnerable in every situation, but any user can be rendered vulnerable when a system knows more about them than they know about themselves, adapts faster than they can reflect, and uses that asymmetry to secure an outcome against their interests. The legal task is therefore not to infantilize the user. It is to discipline the environment. That means looking beyond the visible interface. It means asking what the system infers, how it adapts, what it optimizes, and whether the resulting choice environment respects agency or extracts from it. If you want to go deeper, the argument is developed in my book, Dark Patterns, Deceptive Design and the Law, especially the chapters on AI-powered deceptive design and vulnerability. I'll include links and references in the description. The core point is this: when a system makes weakness profitable, law should stop calling that persuasion, and it should call it exploitative deceptive design. Thank you very much, and I hope you enjoyed this lecture.